first, House File 4822 from Representative Feist. I'd like to move that House File 4822, the second engrossment, be referred to the Committee on Ways and Means. Representative Feist, I understand you have an author's amendment. It's coded A3 in the packets. Should I move that for you?
Madam Chair, that would be great, but note that we do also have an oral amendment. to
Yes.
this.
Okay, great. So I'm going to move the A3, and then I'm going to amend the underlying House File 4822 A3 amendment as follows. Page 2, line 22, after the first comma, insert 85.013 comma. And so now we're going to vote on the oral amendment to the A3. Is there any discussion on the motion? Representative Robbins.
Sorry, could you just restate it? Because I was fumbling for my page.
Yeah. Okay, so on page 2, line 22, after the first comma, insert 85.013 comma. Good, Representative Robbins?
Yep.
Excellent. Is there any discussion? All those in favor of the oral amendment, please say aye. Aye. Any opposed? Motion carries. The oral amendment to the A3 amendment to House File 4822 is adopted. Now to the underlying amendment as adopted. I'm going to move that we adopt the A3 amendment as amended to House File 4822. Is there any discussion on that motion? Seeing none, all those in favor, please say aye. 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 Any opposed, no. Motion carries. The amendment as amended is adopted. Okay, so we also have an A4, which adds the appropriations to the bill to match up with the fiscal note that's in your packets. So I'm also going to move the A4 amendment. Is there any discussion on that amendment? Seeing none, all those in favor, please say aye. Aye. Any opposed, no. Motion carries. The A4 amendment to House File 4822, the second engrossment, is adopted. All right, now that that is done with, Representative Feist, to your bill.
Thank you, Madam Chair. Thank you, committee. This is my first time before the Taxes Committee, so I brought donuts from my district from Heights Bakery. You're welcome. And those donuts are available to anyone who lost sleep over House File 4822. So you all know who you are, and you can grab some donuts too. House File 4822. This bill is in response to the May 2023 unanimous decision by the U.S. Supreme Court in Tyler versus Hennepin County, which found that Minnesota's tax forfeiture laws were unconstitutional. Specifically, the Supreme Court found that the county's taking of the excess proceeds from the sale of tax forfeited land beyond the total delinquent property taxes, costs, and fees owed was a violation of the Takings Clause. The bill before you is a result of extensive collaboration and dialogue amongst stakeholders, including the Association of Minnesota Counties, which convened counties across the state to evaluate the Tyler decision and identify solutions. Legal aid, the judiciary branch, constitutional scholars, the DNR, colleagues on both sides of the aisle, among others, have all been included in the conversation and analysis. I would also like to recognize the extensive research and counsel that nonpartisan staff have committed to this complex challenge. Thank you. 4822 does the following. It makes a public auction mandatory when a claim for surplus proceeds are filed in order to pay out any excess proceeds to the property owner. It creates a process to ensure that excess proceeds on minerals are not retained in violation of the Takings Clause. The amendment modified the allocation of funds to prioritize the property owner before dividing the surplus proceeds. And the amendment also created a process so that the DNR can continue to withdraw from sale forfeited property within public lands without violating the Takings Clause. And note that the appropriations was to the DNR because they will have additional duties under the new structure. This bill addresses the holding of Tyler while keeping many of the aspects of existing law that make Minnesota unique and responsive to property owners, including a long redemption period, payment plan opportunities that extend the redemption window, and ample notice periods. Due to the Supreme Court's holding in May 2023, we must take steps to immediately reform our state tax forfeiture laws. This bill represents a balanced approach to this directive that incorporates the perspective and expertise and hard work of many stakeholders and legislative staff. If we are not able to reform our laws, we are perpetuating a broken system for property owners and adding fiscal liability to the state. This problem will only get more expensive as time passes. I would like to note that this bill has bipartisan authors in both bodies. Representative Davids and Niska are co-authors here in the House. This is a reflection of the bipartisan collaboration and consensus over the need to update our tax forfeiture laws. And I appreciate everyone's collaboration on this. And with that, I will turn it over to the experts.
Thank you so much, Representative Feist. Welcome to the committee. Mr. Rogan, please just introduce yourself as you get started with your testimony.
Good morning. Thank you, Madam Chair and members. My name is Dan Rogan. I'm an Assistant County Administrator in Hennepin County and the County Auditor. And I've been part of the AMC Tax Forfeiture Work Group working on this issue for the past several months. And I'm here in support of this bill and the A3 amendment. And I really want to thank Representative Feist for carrying this bill. I'm not going to go over the Tyler decision, but I want to provide a little bit of background about existing law and how this impacts that law. Under existing Minnesota law, if an owner doesn't resolve their tax delinquency, the property ultimately forfeits to the state in its entirety. The delinquent taxes and costs and any liens are canceled, and the county, on behalf of the state, disposes of the property by selling it or transferring it to another government entity for a public purpose. Proceeds from the sales of forfeited land subsidize county's cost in administering this collection process. If there are leftover funds, they must be distributed to school districts, cities, and counties on a yearly basis. Under this existing law, the prior owner is not entitled to any of the proceeds from a sale after a property forfeits, even if those proceeds exceed the unpaid taxes, liens, and related costs. The Tyler Court, as Representative Feist just indicated, held that by not providing the prior owner with a mechanism to claim cash surplus during this process, Minnesota's law is unconstitutional. House File 4822 changes Minnesota tax law to comply with Tyler, and it does so by making really two significant changes. First, it creates a process for us to determine whether there's a surplus. It does this by requiring a public auction for all tax forfeited land. The auction is important because it determines the value of the property. Before the auction, the county auditor will calculate the minimum bid for a tax forfeited property. This will be the sum of delinquent taxes, penalties, special assessments, and other costs. If no one is willing to pay more than the minimum bid, there is no surplus. The county may dispose of the property as otherwise allowed by existing law, for example, by transferring it to another government entity. If someone is willing to pay more than the minimum bid, the property is sold to the bidder, and the amount above the minimum bid is considered surplus that the prior owner and other interested parties in the property are entitled to as a matter of law under the 4822. The second thing it does is it creates a process for returning the surplus to the prior owner or others interested in the property. After the sale, the county auditor is required to notify interested parties of the surplus, and these parties have a claim to that surplus. If the prior owner is the only claimant, the county auditor sends the surplus to the prior owner. If the claimant, if there are multiple claims, the county auditor can file an action in district court, and the court will determine who's entitled to the surplus and the amount. So with that, we are in support of the A3 amendment as well, which made a number of technical changes and really clarified that the allocation process in existing law for when, after we've taken the surplus and provided that to the prior owner or those interested in, who have an interest in the property, follows the existing law right now and allows us to pay for costs and then to make sure that we can pass along any of those proceeds that are in excess of what is required for us to administer this process to cities and school districts. We have just three technical changes that we've been talking to Representative Feist about the definition of the minimum bid, the definition of interested party, which are technical in nature, and we look forward to working with Representative Feist to make those done, but they're not any substantive changes to the bill. And so with that, Madam Chair, I'm happy to answer any questions.
Thank you very much, Mr. Rogan. So if you could stick around while we hear from a couple other folks in case anyone has a question for you when we get to member discussion, that would be great. Next up, Julie Marinucci. Welcome. Please just state your name as you get started with your testimony.
Thank you, Chair Gomez and committee members. We really appreciate being here to support this bill. My name is Julie Marinucci. I'm the Director of Lands and Minerals for St. Louis County. And we have appreciated the support and the work of our author in establishing this bill, and then also Representative Lisselgard and his support in helping shepherd this important bill through the legislature. St. Louis County manages over 900,000 acres of tax forfeited land. So when this ruling came down, it was really important that we made sure that this bill and the resolution reflects the unique nature of northeastern Minnesota. Collectively, the northern counties hold over 2.4 million acres of tax forfeited land. Those lands are used for timber management, they're used for recreation, they're part of an integrated public lands base that generally serves northeastern Minnesota. And so the establishment of the solution as it relates to Tyler really had to take into account that many of these forfeitures happened back when the forfeiture laws came into effect in the late 1930s. And the other piece that's really important in northeastern Minnesota is the mineral wealth that we've got. And so any resolution with this bill had to make sure to protect the mineral estate. And we've appreciated working with the DNR and within the AMC working group to figure out what that path looks like, because it was a little bit more complicated to figure out that unique nature. So the bill at this point accomplishes all of those things, which is quite a feat, and we appreciate the support. The other piece in here is the apportionment. So the management of that land base, that over 2.4 million acres, we generate revenue off of that, and we support entire industries, our entire logging industry. It's really important. And those revenues, again, come through, as Mr. Rogan had indicated, through that apportionment process, and it goes back to the schools, the communities, and the counties in those areas. So with the amended, the A3 amendment of House File 4822, we believe that this accomplishes all of the main goals for northeastern Minnesota, and we appreciate the support in the bill.
Thank you very much, Ms. Marinucci. Up next, I have Jill Schlick-Wynn. If you're present, could you just say your name as you get started with your testimony? Welcome to the committee.
Good morning. My name is Jill Wynn. That's spelled Nguyen, and I'm an attorney at the Department of Natural Resources. Thank you for hearing DNR's concerns with this bill. I also want to thank Representative Feist for working with the DNR to address its concerns. This bill requires that tax forfeited properties are sold by public sale, and when the properties are sold, the mineral rights are transferred to the state of Minnesota. This provision is consistent with Article 11, Section 10 of the Minnesota Constitution, which requires that the state reserve mineral rights in properties that it transfers. If a landowner alleges that the value of the mineral rights transferred to the state exceeds the delinquent taxes, assessments, penalties, and costs, the DNR commissioner must determine the value of the landowner's mineral rights. The landowner is then entitled to a payment from the DNR of the excess amount. DNR has three concerns with this bill, but Representative Feist has addressed one of those concerns with the amendment that she has proposed today. First, the bill as originally drafted required an auction even for properties that have typically been withdrawn from sale. For example, tax forfeited lands in state parks, certain tax forfeited lands on meandered waters, and lands subject to mining permits or leases are typically withdrawn from sale. Representative Feist's amendment addresses this concern by allowing DNR the option to condemn these lands. In cases where DNR would condemn these lands, the prior owner would have the opportunity to claim surplus condemnation proceeds. Second, the bill requires the DNR to determine the value of the landowner's mineral rights if there is a claim for surplus proceeds. DNR does not employ staff who work in the area of mineral valuation. DNR would need to retain additional staff to do this work. DNR's fiscal note estimates that we would need the following staff. We would need 1.5 full-time equivalents in in-house attorneys, 3 full-time equivalents in mining engineers, 2 full-time equivalents in economic geologists, and 1 full-time equivalent in a project manager. Third, because landowners could file claims challenging DNR's mineral valuation, DNR estimates that we would need to reimburse the Attorney General's office for about 1 attorney and 1 paralegal's time per year. Thank you for hearing the DNR's concerns with this bill.
Thank you, Ms. Nguyen. Finally, Kylene Lindgren. Welcome to the committee. Please just state your name for the record as you get started.
Thank you. I'm Colleen Lindgren, Legal Policy Manager at the Pacific Legal Foundation. Chair Gomez and members, thank you for your time today. Pacific Legal Foundation is a nonprofit public interest law firm that represents our clients free of charge in challenges to their constitutional rights. We represented Geraldine Tyler in the Tyler v. Hennepin County case, which set this bill in motion. And we really appreciate the opportunity to work with Representative Feist and others on this committee and elsewhere who have been invested in making sure that Minnesota's tax forfeiture process is made constitutional. And I'm not going to belabor any of the great points that Representative Feist and the other testifiers have made, but I wanted to let you know that Pacific Legal Foundation supports House File 4822 in its second engrossment, as well as the amendments that were offered and accepted today. And we believe this bill provides clarity to all parties, improves notice requirements, requires the sale of property and proceeds to former owners in an appropriate manner. And we really appreciate your support for this bill.
Thank you, Ms. Lindgren. That's the end of folks who've signed up in advance. Is there anyone else present who wishes to testify on House File 4822? Not seeing any, we will move to member discussion. Representative Swedzinski.
Thank you, Madam Chair. Just a general question along these same processes. We've often said, I think we're kind of moving along that line of how we adequately look at land when it comes to state assets that are under their control, whether it's a tax forfeiture, whether it's a school trust land. And, one of the issues that we've been having, especially with school trust lands, that's not necessarily a related issue, but something to talk about is, the DNR is essentially, if they're closing down development, if they're closing down mining, if they're closing down timber on school trust land, essentially that's a taking from the kids. And, I think what we're trying to get after here is a little bit of that same mindset of where does the value, is there value above and beyond what was owed when the tax was owed and the land was taken over, and how would people be potentially reimbursed for that? But something just in general to be thinking about is, if there is essentially a copper mine sitting below school trust lands and the state is withholding it because it's currently under DNR management, that the students, in order to keep that land from being developed, should be reimbursed with the idea in the same process that a mine would be actually used in the revenue generated from it. So I think that's something we should be looking forward to, as a state, to say we can't just hold these things in perpetuity without actually developing them in a real manner and saying, well, it's being used, but we have a picnic table on it, when the real value is what's underneath. And I think representatives around this table would agree that, the kids deserve better. It's not just tax accounts, but it's also the assets that they currently own are exceptionally important to develop in a manner, or at least be reimbursed in a manner that would reflect their true value. So that's my comment.
That is a little outside the scope of 4822, but it looks like Representative Feist, if you had anything to.
I guess I was just going to say the same thing. So under current law, the mineral rights already forfeit to the state, and this doesn't change that. So it's kind of like adjacent to this bill.
Thank you. Representative Anderson.
Thank you, Madam Chair. I think this is I'm going to commend you. This is a sticky situation, right? And I think this is a good solution. So bringing all the stakeholders together was a good job. So thank you. I support this.
Thank you. Any further member discussion? All right, seeing none, I just, before we go back to you for final comments, I am so thankful to you for doing this work. It's like not maybe glamorous. There are a lot of people in this room who have put a lot of time and a lot of effort into this. And before Representative Feist stepped up to kind of coordinate this very complex process, Chair Lissegard and I were trying to do it, and it wasn't going as well as it has gone. Let's just say with a very detail-oriented attorney who's so just fastidious about everything on the case. So just my sincere, heartfelt thanks to you. It's sort of like a thankless job for the state, for the people of Minnesota that you've done, and I'm really very grateful. So with that, any final comments you have, Representative Feist?
Thank you so much for the kind words. I don't feel like it was thankless. I'm really grateful for the opportunity. It's so important. I've learned a lot. And it's just been really great working with so many people with a vested interest to make sure that we get this right. So thank you. And vote yes.
Great. With that, I will renew my motion that House File 4822, the second engrossment as amended, be re-referred to the Committee on Ways and Means. All those in favor, please say aye. Aye. Any opposed, no. Motion carries, and House File 4822, the second engrossment as amended, is on the way to the Ways and Means Committee. Thank you, Representative Feist.